You are alive.
Lori Vallow wants a new trial. Should Brian Kohberger get the death penalty if convicted? Elizabeth Holmes is in her new home in prison. Self-defense is a defense when you are actually in danger. Trust but verify. And then finally, our dumb criminal of the day. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment, and hit that little bell for notifications. And remember, you can listen to us anytime on any of your favorite podcasting apps. I hope you all had a great Memorial Day weekend and hopefully took a moment to pause and reflect on all the people that made the ultimate sacrifice so that we can have the freedoms and the Constitution that we have today. All right, let's go ahead and support the sponsor of tonight's show. Go to crimetalksearch.com where you can sign up for that background subscription service. And if you do, you'll be happy that you did. And remember, you can do as many background searches on anyone in the United States as you desire when you have that subscription, and you can cancel at any time. But when you type in the name of the person, they're going to ask you some questions, and a report is literally going to be generated while you wait, and it will be emailed to you. And it's going to have information in there that you want to know and find out. Sometimes it's going to be good. Sometimes there's nothing there, which is good as well, but you need to find out. So if somebody new is coming into your life, now is the time to check them out. Don't ask those questions, when things go completely awry. Go to crimetalksearch.com. Sign up for that background subscription service today. All right, we're going to do a bit of a hybrid show today. Why did we not put out a regular show? Well, we had to be in court, and we had to be in court twice today. Why? First time, because I didn't bring my client into court, and second time, we just didn't have enough time to do a daily show. So we're going to do a hybrid. We're going to bring you our stories for the day, and then we'll take your questions as well. So first on the docket, let's go ahead and open the record for today, May 30th, 2023. And now we can open the docket. First on the docket, that's right, Lori Vallow wants a new trial. And frankly, some of her attorney's points aren't bad. Now, do I really think that Judge Boyce is going to give Lori Vallow a new trial? No, because he thinks he gave her a great trial, even though the court allowed in a bunch of 404B evidence. 404B evidence, that just shows weakness in a prosecutor's case, that they don't have enough evidence, that they got to show all this other bad stuff. And they say, but don't use it to say she's a bad person. But it is. That's what it's there for. And it's just not good. So let's just go through the motion that was filed by the defense requesting a new trial. Standard court language comes now the defendant through her attorneys, and pursuant to Rule 34 of the Idaho Criminal Rules, they move the court for a new trial. And it says that the court can do it anytime. The motion has to be filed within 14 days of the verdict. This verdict in this case was completed on May 12th, and the filing is within the 14 days. And it says that a new trial may be granted in the cases only when, one, the jury has received any evidence out of court other than the resulting from a view of the premises, when the court has misdirected the jury in a matter of law or has erred in the decision of any question of law arising during the course of the trial, and when the verdict is contrary to the law and the evidence. So the first point that the defense wants to make is the court misdirected the jury in a matter of law as it related to the jury instructions on conspiracy. And Lori Vallow's attorneys note, the indictment filed by the grand jury on May 25th, 2021 states that conspiracy is Chad Guy Daybell, Lori Noreen Vallow, and Alex Cox, deceased, and other co-conspirators, both known and unknown. This language clearly states that at least 5 people entered into the conspiracy: Chad, Lori, Alex, and other co-conspirators. The trial court, however, at the government's request, allowed the trial jury to consider a conspiracy of only 2 people, Lori and Chad, Lori and Alex, or Chad and Alex. This change of the definition of conspiracy from the grand jury to the trial jury completely changed the complexity of this case by allowing the insertion of the and/or language. For the past 2 years, the defense has been put on notice that the conspiracy involved at least 5 people. This notice was clear from the language of the indictment. To have the government and the court permit a conspiracy of just 2 people instead of 5 was prejudicial and unlawful and should require a new trial. That's probably not their strongest argument. Really, most conspiracy allegations always include both people known and unknown. It's just a standard pleading. So I don't think that is going to do it. But this is, I think, where maybe they have a shot. The court misdirected the jury in a matter of law as it relates to the amended indictment. Now, remember, the court brought it up right before the prosecution was ending their case. Now, remember, the prosecution had filed this indictment for 2 years and waited to the end of their case and say, "Oh, judge, we put the wrong subsection in the statute." The judge was like, "Are you kidding me? Can't believe somebody noticed it. But you're the prosecution, so I'm going to go ahead and allow it." Unbelievable. I've never seen anything like that on an indictment case ever. But the rule in Idaho says prosecution, you can do whatever you want. Is it fair? Probably not. Most of the rules, obviously, in the criminal code are not written to favor the defense. You get the constitutional rights, and that's about it. Everything else goes for the prosecution. And it says the court misdirected the jury in a matter of law as it relates to the amended indictment. At the close of the evidence in this case, the government moved to amend the indictment 2 years after it was filed by the grand jury for a clerical error. The amendment was not a clerical error, but changed the statute in the definition of grand theft. I totally agree. The amendment was not, repeated attempts by the defense to remand the indictment last year were objected to by the government and denied by the court. The court should have likewise denied the government's request to amend the indictment. Whether the language of the grand theft charge included intent to deprive or intent to deceive was an element of proof to be determined by the trial jury and should not have been amended by the government. Now, I totally agree with the defense on this one. I think it made a complete travesty of a mockery of a sham when the government gets to amend their indictments for a completely different subsection that they've had 2 years to notice and change. They've litigated. The defense all but said, this charging doesn't make any sense. We're confused. Remember all the bills of particular that the defense filed and the prosecution poo-pooed it and said, "Oh, defense, it's in the discovery. You know where to find it. Why are you bothering us with such things?" Okay, you sure about that? Okay, just want to make clear, this is what the statute is. This is what you're proceeding upon. The judge had an opportunity, but no, like a typical judge, completely sides with the prosecution. And then it's not until the last moment that, and that, don't get me wrong, Judge Boyce is relatively new to the criminal bench, is my understanding out there, recently appointed to the bench in and of itself. And this is the kind of things that happens to a young judge. A young judge takes the word from the prosecution as gospel because they think, well, they have a duty to protect the record. No, they're advocates. They're trying to win. People forget that. Prosecutors are not there for justice and the flag and American pie. They're there to win. Don't confuse anything about what a prosecutor does. They're there to win. And this is the kind of crap that they get away with, and they get to keep doing it because the judges keep going along with it. And it's not until these judges have been on the bench and, they get reversed a few times because they listen to the prosecution that, well, maybe they start making their own judgments and reading the statute and say, I got some pretty experienced defense attorneys over there. They're not filing a bunch of frivolous crap. Maybe I should probably read what they have to say. Most experienced criminal defense attorneys don't file a bunch of boilerplate motions. And, they're like, hey, they save their good motions. It's like a silver bullet. You're firing it because you're trying to make a point. Judge Boyce should have learned that. Third, little juror misconduct, perhaps. A juror interview revealed that jury instructions were confusing and that he knew of evidence not submitted to the jury. Juror number 8 was interviewed by East Idaho News on May 17th, 2023 in Boise, Idaho. The juror and the reporter were very respectful of the process. Roughly halfway through the interview, an interesting discussion takes place for 2 minutes as follows. Reporter, having seen all the evidence and all the thousands of hours spent, how would you describe the efforts of law enforcement? Juror, they did a really good job with what they had. I don't know that you can ever train for something like this. I think they did a good job with what they had. You question some things, what happened. I'm sure there's a reason for it. You question, had some things been done differently early on, would any of us be here? Reporter, do you have an example of one of those things? Juror, we didn't consider this during our deliberations because it was clear to us the instructions were clear. Arizona evidence and testimony is only for demonstrative purposes. Reporter, sure, yes. Juror, and we were all very, very respectful of the rule, the directions that we were given. But now being removed from that, I think the police department in Phoenix had some significant red flags that they had been, if they've been followed up on, maybe we're not here. Reporter, do you mean after Charles was shot? Juror, before and after. Reporter, before and after. Yes, you're right. Before he was shot with the body cam. Juror nods in affirmative. Reporter moves on to another line of questioning. Then this is Lori Vallow's attorneys. This question and answer between the reporter and the juror make clear that evidence permitted under Rule 404B, Idaho Rules of Evidence, is confusing to the jury. The defense continually objected to 404B evidence, and this is a very good example why. Arizona evidence and testimony was not for demonstrative purposes, as the jury stated and the reporter agreed, but was evidence to show some reason other than bad character. The demonstrative evidence allowed in this case was the summary evidence from the law enforcement witnesses. To confuse demonstrative evidence and character evidence is easy to do. Hence, the defense objections should have been sustained. The second problem with the jurors' comments are that Charles Vallow's statements to law enforcement were not part of the evidence presented in this case. The juror and the reporter referred to it, but it wasn't presented in court. We can only conclude that the juror relied on the information not presented in court to reach his conclusion that Arizona dropped the ball and should have done more, even before Charles Vallow was shot and killed by Alex Cox. The actual recording of this interview can be made available to the court for review. Wow. Little juror misconduct. Jurors talking to reporters about stuff that wasn't presented in court. Now, like I said, 404B evidence was created for the prosecution because when they don't have enough evidence, they try to bring in something for a different person. Yeah, we'll have to see. Just don't think so. All right, I see the super chat. I'll answer the question whether I've sat on a jury. Really quick, we'll do it. Scott, have you ever sat on a jury? No, I've been called to jury service once. That's it. And I didn't even make it out of the little jury commissioner's room. So anyway, let's get through the rest of the docket, and then we can come back and talk about Lori Vallow. If you go back to, what was it, 2 weeks ago, whenever we finished up Lori Vallow? Yeah. I said when they amended the statute, we're not talking about, oh, Judge, we misspelled a name that's completely, it's just a clerical error. No. When you cite a statute and there's multiple subsections and you cite the wrong subsection, that's not a clerical error. That is a charging amendment. And in any other jurisdiction that I've ever practiced upon, I've never seen an indictment amended with a pen change. Unbelievable. That's why when you proceed by indictment, to change it, you have to make sure you get it right, because it's difficult. You have to go back and present all the new evidence when you supersede the indictment if it's not the same grand jury. Big, big problem. I said that's going to be a huge, huge appellate issue. And it looks like it may be. All right, next on the docket, should Bryan Kohberger get the death penalty if he is convicted? Well, at least 2 of the Idaho quadruple murder victims' family want the death penalty for the college students, obviously killed allegedly by Bryan Kohberger. And everybody knows by now Bryan Kohberger is accused of murdering Madison Mogen, Kaylee Goncalves, Zana Kernodle, and Ethan Chapin back on November 13th of 2022. Well, the attorney for the Goncalves family said that their family and the Mogen's family support the death penalty in this case following the murders. Now, obviously, the district attorney has 60 days from the arraignment date to decide whether they're going to do a death penalty case as it relates to Bryan Kohberger. The families will have to be consulted, but ultimately the decision is up to the district attorney. For a death penalty case, normally it's not really a whodunit. It's pretty overwhelming and convincing evidence because nobody wants a weak case to go to trial on a death penalty case. You just don't do it. And we saw how the prosecutors in Idaho completely messed up the Lori Vallow case. And I mean, these guys were a bunch of bumbling boobs. And I really hope they weren't going to be that, but man, they really turned out to be that way. And this whole thing about the summary of evidence that they did, God, it's just terrible. I can't believe the judge allowed it. It's just terrible. We'll see. Let me know whether you think. Should they go death? I mean, we haven't really seen the evidence. How overwhelming is it? Yes, we got the little DNA on the sheath button here, right? Remember the sheath that was found at the house, Bryan Kohberger, right? On the K-bar. But we don't know whatever evidence we have. We're not going to get to see that because we don't get to see the preliminary hearing because the prosecutor indicted, and it's a simple indictment. I got it right here. Count 1, murder in the first degree as it relates to Madison Mogen. Count 2, Kaylee Goncalves. Count 4, Zana Kernodle. Count 5, Ethan Chapin, and obviously the burglary count was first count. So, yeah, there you go. Simple. All right, next on the docket, Elizabeth Holmes finally had to report to prison today. She's starting her 11-year sentence after losing her last request for an appeal to remain free while her case was up on appeal. Didn't quite work out the way she expected that to. Now, she's expected to serve her time at a minimum security prison. It's Federal Prison Center Bryan, which is located in Bryan, Texas, about 100 miles outside of Houston, where Holmes actually grew up, aspiring to be a billionaire like Steve Jobs. If she stays at this facility, the mother of 2 will share bunk beds with a prison cell and at least 3 other women. More than likely, she's going to spend a couple of days in solitary, making sure she understands the prison rule books. She will live among some other famous reality stars that are there. There's Jen Shah and Jenna Ryan, who are convicted for participating in the January 6 riots. There's also Shah starred on the Real Housewives of Salt Lake City. She began a 6-year sentence after being convicted for participating in a telemarketing fraud scheme. It's a prison camp, and it holds about 700 inmates, and most are serving time for white-collar crime. Inmates live in a 4-housing unit where cells open at 6 a.m., and inmates must return to their dormitories for a head count at 10 a.m. and 4 p.m. Now, obviously, Holmes, who was living the life of a billionaire, well, it's going to be a complete change. And guess what? She's not going to get to see her kids. Remember, she has 2 kids now. and her husband, William Billy Evans. They married back in 2019, and Holmes gave birth to her now 1-year-old son, William, in July of 2021, which actually was the reason for the delay of her trial originally. And then Holmes announced that she was expecting another child, her daughter Invicta, now 3 months old, back in November of 2022, following her conviction earlier that year. Some people will do anything for sympathy to stay out of prison. Doesn't really work. And don't forget, that's right, Holmes has to pay restitution along with Sonny Balwani, her former boyfriend and COO of Theranos. Yeah, $452 million in restitution. And remember, some of that money will be taken from her books. So any money that she has to buy commissary in prison, they're going to take a little bit of it and spread it around, that $452 billion, to the victims. Now, don't get me wrong. I've said this about white-collar cases. White-collar criminals are some of the most manipulative people you will ever meet. The only other people that are probably more manipulative, well, people that do terrible things to children, okay? You know what I'm talking about. They just think they can always solve the problem. They can fix it if, just had a little more time, a lot of gaslighting, everybody else can do it. And I've always said this on a white-collar crime case. And here in the Theranos case, we were talking about some pretty sophisticated people. We're not talking about, little moms and dads giving up all their retirement money. I mean, we were talking about secretaries of states, former secretary of defense, billionaires giving money. So there should always be a greed factor when it comes to white collar crime, because all those people thought they were going to be rich and they ignored all the signs. They ignored doing any of their due diligence. And if you don't do that, it's like a civil case. You kind of have an assumption of the risk. You don't have clean hands, but they don't really care in the criminal case. So don't get me wrong. Elizabeth Holmes needs to go to prison. She needs to pay back the money. And that's the problem when you take other people's money. You have to do exactly what you promised. Otherwise, when it goes south, it wasn't, it was just a bad business decision. It was fraud. And that's what happened here. All right, next in the docket, you can't do this. You have to actually, to claim self-defense, you have to actually be in serious fear of death or serious bodily injury. Remember that. So like in this story, when somebody's running away from you, there's really not a danger, unless maybe they're shooting at you, but that wasn't the case here. So a South Carolina gas station owner has been charged with murder for shooting a 14-year-old armed teenage boy in the back while chasing him down the street because he thought he had stolen a bottle of water from his gas station. Now, Rick Chow is the owner of the Shell gas station in Columbia, South Carolina. And on Sunday night, about 8 p.m., Cyrus Carmack Belton, this kid's 14 years old, entered his store while visiting family in town. Chow and his adult son, who police say are regularly besieged by shoplifters, suspected Cyrus of trying to steal bottled water. So what's the natural thing that you do? Well, let's read on. Police say that surveillance footage proves that Cyrus did not steal, but the footage has not been released yet. So when Chow and his son confronted Cyrus, he ran out onto the street. Chow's son gave chase, running him into the street. It was then that he realized that the 14-year-old was armed and shouted to his father that he has a gun. Chow, who owns a pistol, shot Cyrus once in the back, and the teenager died as a result of the gunshot wound. Now, the gun that Cyrus was carrying was found near his body, according to police, and it remains unclear how he obtained it. Well, he obtained it illegally since he's a minor. Why can't the people just state the obvious? He shouldn't have had it. Just saying. Not saying an excuse to get shot in the back, but let's say it what it is. He was 14 and he had a gun, and he shouldn't have. Well, the store owner has now been charged with murder. And the Richland County sheriff, a guy by the name of Sheriff Leon Lott, condemned the men. You don't shoot somebody in the back if he's not a threat to you. It's the same standard that we do, the cops. We have to live by it. You have to be defending someone's life or your life. There has to be an immediate danger to you. Someone who is running away has no indication that he is pointing a gun at anyone while he's running away. He was shot in the back. And even if he had shoplifted 4 bottles of water, it's not something that someone gets shot over, let alone a 14-year-old. A sheriff deputy added that there was no indication that this young man was fighting with the store owner, and he has no wound on his hand, scratches, no bodily injury or anything along those lines. And the police will not reveal whether or not the juvenile has a criminal record. Well, protesters descended on the gas station. Yep, that's right. They basically destroyed it, spray painted the walls in the store, and poured bottles of water in the parking lot. Now, Chow has a history of only a few traffic violations, but he doesn't have any criminal history with any violence. Police have been called to that particular gas station frequently in the past to deal with shoplifters and other violence. Yes, not good. Not good. Just remember that, ladies and gentlemen, self-defense, fear of death or serious bodily injury, imminent. Be running away unless hopefully you got some video of them pointing the gun at you. That is self-defense, but not running away. Just poor guy. He's probably going to prison. Let's just say it the way it is. Now, this kid didn't shoplift. He doesn't deserve to be shot. That's for sure. But with some of the shoplifting going on in the world, maybe if the law was changed that you could shoot somebody for stealing your property, like back in the good old days, the wild, wild west, you never took somebody's horse, you didn't steal their cattle, they would hang you. Just saying. Something to think about. That's all I'm saying. Next on the docket, trust but verify. Yes, we've all heard of ChatGPT, but trust but verify, ladies and gentlemen. You know, the old stuff about programming computers, garbage in, garbage out. It's only as good as what they put into it. Ask Stephen Schwartz, an attorney with a fancy law firm in New York. Well, what came up is that he asked ChatGPT to find cases relevant to his client's lawsuit, only for the bot to, well, make them up, according to court documents. Now, the snafu apparently began when Schwartz's legal partner, Paul LaDuca, filed a lawsuit against the Colombian airline Avianca, A-V-I-A-N, Avianca. Thank you, Frank. Avianca, on behalf of Robert Mata, who was allegedly injured when a metal serving cart struck his knee on a flight to New York City. When the airline's lawyer asked the court to toss the lawsuit, Schwartz filed a brief with all the supporting authority of half a dozen relevant cases. There's one problem. The cases that they cited, Miller v. United Airlines, Peterson v. Iran Air, and Vargas versus China South Airlines, were completely made up by ChatGPT. 6 of the submitted cases appear to be bogus judicial decisions with bogus quotes and bogus internal citations. In a sworn affidavit filed last week, Schwartz admitted that he used ChatGPT while compiling the paperwork that LaDuca filed, writing he relied on the legal opinions provided to him by a source that has revealed itself to be unreliable. The little mea culpa from the attorney went on to say that Schwartz was unaware of the possibility that ChatGPT content could even be false. Anyway, the lawyer also told the judge that he greatly regrets using AI for legal research and will never do so in the future without verifying its authenticity. Peter LaDuca, the law partner, also wrote in an affidavit he was not involved in this malfeasance and had no reason to doubt the authenticity of the case law, even though it was completely made up. LaDuca added that he had worked for Schwartz for 25 years and never could recall a single situation of him looking to mislead the court. But just goes to show you, ladies and gentlemen, ChatGPT, only as good as what goes in and what they search. That's it. Doesn't have all the answers. Garbage in, garbage out. Just remember that. And then finally, our dumb criminal of the day. Please meet Andrew George. He's in jail for breaking into a home because he claimed that a ghost was chasing him. So George was booked into jail last week for a couple counts of burglary. And according to the arrest affidavit, dispatchers were called to a Daytona Beach historic home for a shooting. But it turned out to be an actual burglary. Now, when the officers arrived, they found a man later identified as George laying on his back on the front steps of the home, covered in blood and crying in pain. Now, he had an accomplice, Natasha Couturier, who was standing over him. Now, George and Couturier had purchased a room at a nearby Travel Inn. Well, they were in the room for about 30 minutes when they claimed they heard a window opening and thought that somebody was trying to break into their room. The two allegedly then ran out of the room and demanded a refund from the motel manager, arguing for several minutes. They were refunded the money, but moments later, George and Couturier observed a shadow behind them, according to the affidavit, thinking that it was a person who was breaking into their motel room. The two then ran across the street in an attempt to hide from the shadow that they allegedly observed. Now, the duo then ran to a 7-Eleven and asked for help, then towards the Halifax Marina. Now, George kept running around the marina's parking lot due to a ghost chasing him. He told officers he was scared of the ghost and scared the ghost was going to harm him. So he jumped into the water to hide from the ghost. Now, his female counterpart thought that George fell into the water, so she allegedly helped him out, and the two ran to a neighbor across the street, according to the police report. Still fearing the ghost was chasing him, he approached a few homes and banged on their front doors, screaming for help. His female accomplice allegedly said at one point, George grabbed a chair and smashed it through one of the home's window, then punched open a window. Because, if the chair doesn't work, use your hand. The people living inside called 911, obviously, and they threatened to stab him with a kitchen knife if he didn't leave. George allegedly told the officers he couldn't get into the home due to God telling the female was a bad person to hang out with. And according to the affidavit, the suspect also told officers he heard children's voices and didn't want to scare a child. Well, Mr. George admitted to taking a little bit of Molly, and also, that's known as ecstasy, and that's why he believes that God was not protecting him from making such poor choices. Blame it on God. That's where you go. There you go, Mr. George. Don't blame it on the Molly. Blame it on God. All right. Our dumb criminal of the day. All right. That's our hybrid show for you. We're going to continue to go. We're going to take some questions that people have. I think I answered the one super chat. Now, remember, we don't beg for super chats, but yes, it does help highlight. It does help highlight your question so I get to see it. Nope. Let's see here. I just saw this. Lori can get 10 death penalty convictions, but she's probably not going to be executed because she has served her penalties from the first trial. Well, remember, the judge threw out the death penalty against Lori Vallow because the prosecution screwed up the case. They failed to turn over discovery, right? She's convicted of killing both her kids and convicted of killing her new husband's ex-wife on a conspiracy. And the prosecution couldn't get their act together again, so the judge threw out the death penalty. I'm telling you, ladies and gentlemen, I had a boss in the military years and years ago. He had good things. He said, first of all, I said, why are we doing this, sir? We're going to have to fly people in from all over the world. Is it really worth it, et cetera, et cetera? And he said, justice is expensive, and there's always money for justice. Because, throughout the Lori Vallow trial, what did we hear? Oh, it's so expensive to do 2 trials. We just can't afford it. There's always money for justice. And I've learned over the years that a good prosecutor will say, I will give you everything that you want, and I'm going to convict your client. Bottom line. It's always those prosecutors that play games, that don't turn over discovery, that always have an excuse for everything. Those are the bad prosecutors. Those are the ones you need to look out for. Okay. Did you see this kind of nonsense going on in the Alec Murdaugh trial? No, You had experienced career prosecutors there. No issues. No issues. Straightforward, clean trial. Strong judge. And I just look at what the hell happened in Idaho, and I mean, I was hoping they were going to do it right, that there weren't going to be any issues, but the prosecution screwed this case up, and I hate to say that. And, the Court of Appeals will probably, we'll just, it's not that big a deal. I mean, it's only the wrong section of the statute. I mean, it's not like the defense couldn't have known, but when the defense tried to clarify that, and this is the crap, and I'm telling you, excuse my French, I'm sorry, but this is the kind of stuff that just irks the hell out of me, okay? I had a trial, very similar circumstances. I make this big issue about it. Everybody poo-poos me. I object to trial. Object. Guess what? Case comes back 3 years later on appeal. Yeah, maybe you should have listened to that Reich guy. Maybe he's not as dumb as he looks. Another case, judge, you need to give this instruction. I mean, just saying, judge, no, all deference to your honor. You got the big black robe on, but been doing this a little longer than you have. And here's this opinion, says Supreme Court says you got to give this instruction. Well, I'm not going to give it. Okay. 2 years later, case coming back. It just drives me nuts when judges don't listen to the defense attorneys and they take the word of the prosecutor. The prosecutor is going to lead them astray every time. Remember, they're trying to get a conviction. They're not trying to do justice. They didn't say, "Oh, judge, sorry, we're going to dismiss. Judge, we screwed up." No, because they're going to look stupid. And what's really going to look stupid is Judge Boyce is going to deny this motion. Maybe they'll have a hearing on some juror misconduct, but by then the prosecution will got to them. And, I didn't understand demonstrative evidence and 404B evidence. I'm not sophisticated in those big legal words. And so I probably misspoke, and no harm, no foul. And maybe it won't be, years down the road, but maybe Court of Appeals will look at it and say, God, we think Lori Vallow, she did it. Probably no doubt that she did it. There was a conspiracy that she did it. But when the prosecution screws this up so badly and the judge doesn't hold anyone on the prosecution side accountable in any way, I mean, let's face it. If this was a death penalty case, she would be getting a new trial right now. The fact that death is off the table is probably the only reason why the prosecution will prevail. And like I said, I'm not saying Lori Vallow's innocent. I mean, the jury found her guilty. Pretty convincing that, she had old Chad and Alex wrapped around her little finger, and she was going to do everything she can to make things a little easier for her. Get rid of those pesky children. They're such a burden, a lifetime of responsibility. But she's entitled to a fair trial. I mean, I called it. I thought it was legal error when the judge allowed them to make those changes. I really do. And if it comes back, I think that's going to be the big issue here. The other stuff, yeah, not so much. But the mere fact that they changed the statute, the defense relied upon it. Now, frankly, I wish the defense would have made a little bit better of record. And don't get me wrong, there's a lot of blame to go around. Like I said, I think the defense was dealing the best they could with what they had to work with. And it was kind of a technical defense of they didn't prove it. And then finally the prosecution figures it out the last 30 minutes in their case in chief. And then kind of the defense goes away. They figured the judge would no way let them amend that far into the process. Most judges wouldn't allow you to do that. So I don't know. We will all just have to wait and see. But let's see a show of hands. Okay. Show of hands. Raise your hand, right? Raise your hand if you think Judge Boyce is going to declare a mistrial and give Lori Vallow a new trial. Show of hands. Yeah. Me neither. Neither do I. Nope. Not going to happen. Okay. And Kathy, I don't think the defense had a chance in hell. I don't think they did either. But the prosecution gave them a fighting chance. That's what I'm saying about. That's what I'm talking about. This should have been a slam dunk case. They had 2 years to perfect their evidence. They had 2 years. They had 2 years to get all their ducks in a row, to get it right. So there's no issue whatsoever. Overwhelming evidence. And the prosecution managed to screw it up. First, okay, it takes a lot for a court to dismiss a charge because of discovery violations, let alone a death penalty case. Say, yeah, I'm not going to let the prosecution go forward on the death penalty, because even the judge was like, oh, yeah, we can't do this. This is a total violation of someone's due process rights. They have a right to speedy trial. I told the court ordered the prosecution to turn over discovery by a certain date. They didn't do it. So to sanction them would be one thing, but to take away the death penalty case, right? The only time we saw that was so bad here in Colorado was Barry Morphew's case, where the prosecution once again screwed it all up by not turning over the discovery. It was a weak case from the beginning, and it should have never been charged. And a strong team of defense attorneys called them out on it, and they could never recover. And no offense to small town prosecutors, they're just not used to handling big cases like this, where there's so much digital discovery and they get lost in it. They just don't have the resources to do it. So, question here. So, I'm assuming as attorney has to defend a guilty client if he has enough proof that they're guilty, even if they demand a not guilty plea. Yes, happens every day. I have done trials where it's been on video, where the client's like, I'm not pleading guilty, make him prove it. You're like, that looks like you in the video, man. And I'm your attorney. I'm rooting for you here, all right? But I'm telling you, it's my job to tell you the good, the bad, and the ugly. And, that's your ugly mug right there on the video. No, it's not. That's not me. I put up a mom once to say, is that your baby? Little screen capture. Is that your baby? I know you know your baby, man. Is that your baby? She's like, that ain't my baby. Unfortunately, 12 jurors determined that that was her baby, robbing somebody. So, yeah, you can't have the client testify, but if the client's like, that's not me, okay, he didn't testify, but, I'm just saying, yeah, the prosecution has to prove the case beyond a reasonable doubt, even if it's overwhelming evidence. Why do you think on death penalty cases, just bring it on, prove your case, try to poke some holes into it. It's completely ethical to do that. And then you can argue the reasonable inferences drawn from the evidence or the lack thereof. Let's say there's a shooting case. Well, they didn't recover a firearm. Where's the gun? They're trying to say my guy was a shooter, but where's the gun? You argue that's a reasonable doubt, ladies and gentlemen. They don't have the right guy. They don't have the gun. You got sketchy testimony over here of who's firing, all those types of things. Even if you think, even if the client says, yeah, I did it, whatever, make them prove it. I can totally respect that. I can sit there all week and not say a word. Get up and say, ladies and gentlemen, prosecutions failed to prove their case beyond a reasonable doubt. That's the way the law works. That's the way it works. You may not like it, but that's the law. Let's see. Jesse, shouldn't inadvertently open doors to defense before sentencing, in my opinion. I'm assuming. Not sure what that means. None of the juror instructions were confusing. He followed and respected the rules given by a judge, all jurors. Yeah, I don't think that's a whole lot of I don't think that's going to get a whole lot of play. I think the big appellate issue in the Lori Vallow case is going to be the amendments. The prosecution, I mean, they got their conviction, but hey, you got 2 dead kids. Listen, somebody, I'm telling you, I've done dead baby cases, dead kid cases, usually at the hands of the parents. Give me a good old-fashioned gang shooting any day of the week. But kids, juries hate that stuff. It's, it's almost pretty much a slam dunk. All right, here's a super chat. Can you put that up there, Frank? This is from Jody. This is in regards to the Brian Kohberger case. Do you think we'll hear from the surviving victims, the ones who had sorority and friends over before they called 911, referring to their testimony? At this point, trial. Yep. At trial, more than likely the prosecution would have to call them. But from what we know, the prosecution witnesses can't ID anybody. The identification is coming from the DNA, right? Do I have my marker? I don't see my marker. Let me see if I have my marker. Let me pull out the magic board here. Now, I've done this many, many times before, but for those who haven't seen it, okay, let me pull up my magic board here. Let me explain to you criminal law 101, what you have to prove. Try to do this as clear as I can. I should create a picture of this and we can just put it up and talk about it, but it's LOVID. Okay. Now they got all those other fancy schmancy crime channels. Okay. But none of them are going to teach you this. This is all you need to know. I have a LOVID sheet in every case file I have. It's a quick reference guide. You know everything you need to know about it, about a case. All right. LOVID. You're going to say, Scott, what the hell is LOVID? This is really what the prosecution has to prove. Okay. So what do they have to prove? The first thing they have to prove is location, right? Proper jurisdiction and venue. What do they always ask? Was that then and is it now in the county of blank, state of blank? Because they have to prove that the crime occurred in the state or the county in which the offense took place, right? The offense, we'll just make it easy. Let's just say offense, charge, let's make it easy. First degree murder, right? The elements, they have to prove the elements. So they have to show that somebody's dead at the hands of the other by another without legal justification. Right? Without legal justification. And then either knowingly or after deliberation, right? Knowingly or after deliberation is usually first degree murder. Knowingly is usually some sort of second degree murder. So that's the offense. So prosecution has to show in and come into court and say somebody's dead and that somebody else did it. Okay. We'll talk about how they have to do it. Without legal justification, there was no assisted suicide. There was no self-defense issue at hand. Okay. And that they knowingly did it or after deliberation. The next, victim. Victim. L-O-V-I. Victim. Who's the victim? We're going to talk to Brian Kohberger case, right? You got all the victims there. We've got Madison Mogan, Kaylee Gonsalves, Zaina Kernodle. So how do you prove that they're victims? Well, you bring in the coroner to say that I did the autopsy and that they're dead. I mean, that's really what the testimony is. They're dead. They're no longer a live, living person. So they have to show that somebody is in fact a victim. Let's say if it was a burglary, you'd have to bring in the victim, and the victim would have to come in and say, that's the bad man that came into my house and stole the things, and came into my home with the intent to commit a crime therein. Okay. So in the Kohberger case, the victims may say there was actually a person in there and maybe give enough of a description through circumstantial evidence that it was Kohberger. Now here is the most, well, actually let's do the second most, not the second, but date and time. Prosecutions have to prove the date of the offense. Date and time, not so much the time, but you have to give reasonable notice for the defendant to say, hey, this occurred on, May 30th, 2023. And, we believe that you committed an offense and there were victims and it occurred in the jurisdiction that's prosecuting it. Date and time. Defendant's entitled to know. They're not going to play games like, well, you know what you did. And we're not going to say, because we know that you know that we know that you know that you know what you did. Okay? You can't do that. But here's the biggest thing. In any criminal case, identification. Most important element of any criminal offense. You have to be able to show that it was the defendant. You know, that big moment in any courtroom scene, the prosecutor builds up to it. Oh, tell me about the terrible things that happened that night. Oh my gosh, it was terrible. Tell me more of the terrible things. Now, we've all been waiting for this. Do you see the bad man that did all those terrible things here in the courtroom? And the witness then looks over and says, that's the bad man right there, sitting between the attorneys in the great suit and the lovely tie. The guy that looks like he's in custody, and his attorneys pieced together something from the clothing department, from the public defender's footlocker down there in the jail. That's the guy right there. Oh, are you sure about that? I'm positive it's him. I would never forget those beady little eyes and the scar that he had above his right eye. Identification. It's the most important thing, right? Murder case, though, usually somebody's dead. So how do they come in and do it? That's why it makes murder case so hard. That's why Kohberger case, the sheath to the K-bar. And fortunately for you all, yes, that's right. You get to watch a show where your local lovable criminal defense attorney, well, was in the military, specifically the Marine Corps, and just happens to have his own K-bar. So that's how they're going to prove identification in the Kohberger case. They're going to say that they found not the knife, but the sheath of the knife. And at some point they collected it, put on the gloves. I'm sure there'll be some sort of testimony about how they collected this item of evidentiary value and that they collected it. And at some point it got put into a brown paper bag for safekeeping, placed into the evidence locker where it was indexed and safely held until it was signed out by the lab technicians, whereupon they engaged in all of their good habits of making sure there's a clean sheet of butcher block paper. They did their gloves. They sterilized everything around them to make sure there's no DNA transfer contamination. And what did they do? They took little swabs of this sheath where they think that they could find something of evidentiary value, whereupon they collected that have things of evidentiary value. They then return this back to the evidence bag and back to the evidence locker where it will once again be stored until needed. And then they take that little piece of DNA evidence and they collect it, they inventory it, they put it into safe casing, and then they send it off until the next time somebody's going to take that little swab and they're going to remove it, that little cutting, and they're going to create a DNA sample. When they send it through the little machine, it's going to spit out a DNA sample. And then when they get that sample, they're going to do all that statistical stuff and say, okay, this allele looks like a his, and this is a 17, and this is, and then they're going to say, and we need a known sample of that Brian Kohberger guy. And then they look at it and they put up a big sample on that X's and O's, right? Have you ever seen it? I think we did a show on this probably years ago, but they put up a sample. They'll say DNA from the knife, right? From the sheath. And they'll say Brian Kohberger over here. And so they'll do a little thing and they'll say, well, in this allele, the first allele here, and there'll be like 17 of them, they'll say, well, this was an X and a Y, and this one was an X and a Y, and number 2 was a Y and an X, and then number 3, a Y and an X, and this was a Y and an X, and an X and a Y, and an X and a XXX here, and an XXX here. And so they're going to say that DNA only came from Brian Kohberger. And they're going to say the odds of it being someone other than Brian Kohberger, unless, of course, he has an evil twin running around, and it's going to be some gigantic number. And they're going to say it is like 1 in 650 quadrillion that it could be somebody other than Brian Kohberger's DNA. And the defense will try to say, well, sloppy techniques. All those people came to that house, partied. Brian Kohberger may have even gone to that house. And if the real murderer was in there with the K-bar, and the K-bar brushed up against some DNA that Mr. Kohberger left at that house at a party that he attended, that could reasonably explain how the DNA got transferred to the little button on the K-bar sheath. And after all, ladies and gentlemen, you don't have the K-bar. See, that's how they're going to try to create reasonable doubt, but that's how the prosecution is going to try to prove identification of Mr. Kohberger. And of course, not to mention the phone and how they thought they saw him earlier near the house, etc., etc., etc. So hopefully that makes sense. All right, Frank, looks like I've got a couple super chats here. Let's see here. Scott, do you have a probe a homicide? Oh, pro bono on a homicide. How does pro bono work? Pro bono is when you offer to do a case and do not charge the defendant. I've told this story before. I will say it again quickly. Scott doesn't do pro bono work anymore. Did that. And when you do it for free, you have the same ethical obligations as if you're being paid. And you need to, it's not like, oh, it's a pro bono case, I won't work on it. No, you got to work on it. You got to spend lots of time on it. If you need experts, if you're doing a pro bono, you're probably signing up to pay for the experts, investigators yourself. So Scott doesn't do pro bono any more. Scott doesn't need any publicity. Scott just wants to get paid for his time and experience. Let's see. What was it? Was there another one, Frank? I thought that was it. Okay. Do you think we'll hear from the surviving victims? Yeah, we did that one already. Okay. And do you do a pro bono on a homicide? Nope. We don't even do pro bonos for friends. That's just the way it is. The problem is when you do something free for a friend is you're thinking, hey, I'll do it when I kind of get around to it. Like a little traffic ticket or something, right? Like, hey, can you help me with this traffic ticket? No, but they're thinking you're working on it like you're paying them your hourly rate. It just never ends well. So you treat everyone, I hate to say it, as a client, even friends. You have them sign a fee agreement, you get it, have them pay. It's just the way it is. Just saying. All right. See if there's got some more questions here that we can answer. Now, do not forget, if you're not a Patreon, gosh, can you believe I've already been talking an hour? It goes by so fast. Jesse, in the back can't never be self-defense. It could be, maybe if they were holding a gun at you while they were running and firing. What's this? Man, my law professors are spinning in their graves over this. Who would do such a thing? A lazy lawyer? Huh. Oh, ChatGPT. Oh, yes. Imagine that. I mean, not even to check it. Oh, man. Jeez. Maybe the juror. Let's see. If it helps, one of the first things defense attorneys tell their clients is, if you did this, don't tell me, seriously limits what they can do at trial. No. If it helps, one of the first things defense attorneys tell their clients is, if you did this, don't tell me. I don't do that. No, it doesn't limit anything. I think that is more folklore. If the client said they did it, listen, I tell clients, tell me the good, the bad, and the ugly. Okay. I've won many a trial where the client has said, I did it. Prosecution couldn't prove their case. And maybe I knew they couldn't do it because they were completely honest with me. I knew that the prosecution was looking in the wrong place. They didn't have the evidence. I think of the old, well, so don't tell me what to say. No, that's going to come back and bite you in the butt later on. Well, I tried to be, with my attorney, and he wouldn't let me tell him the whole truth, and then that way he could have effectively represented me. I think that's more for TV stuff than anything these days. Most attorneys that I know, I can't think of anyone that goes in saying, "Don't tell me this because that's going to limit how I proceed to trial." Tell me if you did it. Like I said, I've taken lots of people to trial that said they did it and they were not guilty. Some were guilty. Sometimes hey, man, you told me you did it, and you're right. They got you over. We need to cut a deal. Be honest with your attorney. I mean, that's the whole point of the attorney-client privilege, is that you get the best advice when you're absolutely honest. It's like you get the best medical treatment when you tell your doctor what's really going on. That's the whole theory behind the attorney-client privilege. It's held in confidence, and therefore you can tell them the truth. You don't have to worry about it unless you get permission from them that they're not going to go tell it to somebody else. So, yep. Lily Lord, super chat. No question, but all right. Thank you. Appreciate that. Let's see here. Mama Pink talking about, because first rule of having a gun, never point at something you don't intend to kill, or at least shoot. The other reason, if you shoot to injure, it doesn't change the threat. They can still kill you. I will tell you this, and I'll say it again. I'm telling you, and the law doesn't listen. I like firearms. Okay. I'd never really been exposed to it until I was in the military. And frankly, you develop a huge respect for it when you see what they can do. You want to develop huge respect for something, you go look at a howitzer shell when it explodes, and the big pieces of shrapnel like this long, and they're all twisted metal, and they're razor sharp. And you're thinking, man, whoever gets in the way of that thing, it's not going to be good. Probably cut somebody in half. Gives you a lot of respect. But as I tell my clients, listen, I get it. Firearms, they're not illegal to have. It's not illegal for you to possess them, although sometimes it's illegal for my clients to possess them. And they complicate everything, right? If you're intoxicated, it's illegal to have it. If you're a convicted felon, you can't have it. If there's drugs around, you can't have it. It complicates everything. If it's in your car, under your seat, unless you're concealed carry permit, it complicates everything. And when it comes to actually firing it, although the law does not require you to say, I tried everything else. Most states, you don't have a duty to retreat and say, I tried to run away. Most states don't have that, but, check your local state before you go doing anything, all right? But the reality of it is you have a right to defend yourself, particularly in your house, right? The castle doctrine, the make my day statutes that are there. If somebody comes in your house and you think you are in fear of death or serious bodily injury, you can shoot first and ask questions later. As long as they're in the house without permission, you're probably good to go. Don't invite over your wife's new boyfriend for a little rendezvous and claim, oh, I was in fear of my life. Don't do that. I didn't know who was coming over, right? You can't do that. Complicates everything, If you shoot them outside, drag them inside. Just kidding. That was a joke. All right. Although I had an attorney once, there was a crazy, crazy client. And I said, hey, man, why did you get off this crazy client's case? And he's like, dude, this guy scares me, my family. We literally have a picture of that guy on our refrigerator because he freaked out my wife and kids. And this guy comes clear the house, call the police. And he's literally like, if he comes near my house, I will shoot him and drag him inside. Okay. Now, fortunately, nothing like that happened. And the guy was crazy, but harmless in the end. but can't go around scaring people. So just something to think about. Let's see. Tina, thinking like a defense attorney. If I were on Kohberger's defense, I would focus on time. It seems like a stretch for him to get in and out, killing 4 people in such a short amount of time. I mean, I think what they have him there as an hour, his phone goes silent after, goes off and then goes on again. But during the time of the alleged killing, they believe it's out. So the police are going to show that it would take this long to get here. And it, started pinging at a particular location, which they believe not accurate. Remember, when they ping, you could be within a 30-mile distance from the tower. But once again, why is your phone pinging in this particular area? Unless the defense can show, well, all those other cell phone towers were out, and that was the only one it could ping upon at 3 a.m. in the morning. We'll see. Hopefully, the prosecution is thinking the way Tina is and trying to combat and refute all of those possible theories that the defense may come up with. Just saying. So, all right. If you're not a Patreon member, you should become one. There's a link down below, I do believe. And guess what? We're going to go do our Patreon show. And yes, that's right. We're going to do the Magic 8 Ball. We got the new Magic 8 Ball. You can see it right there. The lovely Miss Kristen got us the new Magic 8 Ball. And I think it's having a little better odds than the last one. I think we're doing okay on that. And we'll also have the call-in line. And basically, you also get to hear about my Memorial Day weekend. Don't you want to know what I did? Of course you do. Well, only if you're a Patreon member. All right? All right. Thanks for watching. We'll see you next time on Crime Talk.